So my topic here is show cause notice issued for multiple years. So probably I'll just give a brief. My name is Hunny Munjal. I'm a chartered accountant. I have worked close to 7 years in indirect tax, and the topic show cause notice issued for multiple years. It's a very new topic under the GST framework. Just to tell you, it's never been an issue under the erstwhile law, which is service tax or excise. No such arguments or I can say issue have been cropped up under the erstwhile law. This is a very recent phenomena which we have seen in the GST framework. And this has been cropped up by a very new judgment in the case of Titan India Company, but by Madras High Court. In financial year 2024, which is just last year, Madras High Court have given a very important judgment wherein they have favored the taxpayer and they have quashed a show cause notice. The the issue is very new. It is very important to understand and how under the GST framework we can take this benefit and use it for our advantage. And it's never been in the issue under the erstwhile law. Just to take you a little forward, under the erstwhile law, which is the service tax and excise, the normal practice of the GST officer is that for one financial year or multiple financial year, they used to issue one show cause notice or one order, wherein they will typically have multiple issues. They will do one notice which encompasses various financial years. Giving example, financial year 17-18, 18-19, 19-20, 20-21. For all the financial years, there'll be one show cause notice being issued by the tax department. Now, this practice, which is being followed across various years and under the service tax law, has been cautioned now under the GST framework. And very recently it's been done. So it's a very important one. For all our litigation, this could be a very handy one. And probably we will dwell more under this topic in the coming slides. So I'll take you to the agenda of my presentation. I have made four major buckets. First being, what is the legal provision under the GST law, which says under you have to issue one show cause notice for one financial year. So we have to understand from the GST framework what the law says, how the law has been framed, whether the practice of the GST officer is correct or not. We have to understand that. Now, second point, what are the important provisions we have to be very mindful? What is the important point? That's the second point we will understand under this webinar, under this presentation. The third one, precaution. As a taxpayer, if I have received one show cause notice or one order, how will I go ahead with that? Can I take this benefit and simply without going into the merits of the case, I can take the benefit? I can do some help to my client if I'm a consultant or if I'm a corporate. Can I directly quash my show cause notice on the basis of this judgment? Can this judgment be helpful to me? I think yes, we will dwell more into this. Now, the last one. What are the judgments under this? Just to give you little more insights to this topic. Now, as I told you, last year, August 2024, Madras High Court, in the case of Titan Company Limited, has rendered a very important judgment. Now, this judgment typically takes into account Section 73 and Section 74. Now, these are the two most important provisions under the GST law, which typically speaks about assessment. How do I do assessment? What is the timeline? What is the issues are covered under the section GST law for assessments? Section 73, which is other than non-fraud, fraud, suppression, misstatement. If these all allegations are there, then you would have a notice under Section 74. If you do not have any allegation with respect to fraud, suppression, misstatement, typically you would have a notice under section 73. Now I will jump to that specific provisions which I was talking to. Now this is section 73, which says there are four circumstances under which you can receive an order or notice. What are these four typical circumstances? First, tax not paid. So there is a taxpayer who has not paid the tax. So for the assessment of such taxpayer, the notice or order would be provided under section 73 or 74. There is a short payment. He has made the payment, but it is typically short. Let's say, giving example, he is required to make the payment for 100 rupees as a GST and he has paid only 80. So 20 is a short payment. So for this 20 rupees, a tax officer can issue a demand under section 73 or 74. Or there is a erroneous refund. He was not eligible to claim a refund. He has got the refund. So there is a erroneous refund. The last, fourth one, ITC, incorrect ITC or wrongly availed ITC has been availed or utilized, and utilized, I will typically say. So if there are typically four situations wherein there is a demand on the taxpayer, he can receive a demand order or notice under section 73 or 74. What is the difference between 73 and 74? These four important words, which is fraud, suppression, misstatement. If there is an allegation under the notice with respect to fraud, suppression, misstatement, then that order would be issued under section 74 or notice. And if there is no such allegation with respect to fraud, suppression, misstatement, then that order or notice would be issued under section 73. So we have understood, okay, there are two basic difference between 73 and 74. Now, in terms of these allegation, the timeline also varies. For section 73, the timeline is 5 years from the date of filing of the annual return. So there is an extended timeline for fraud cases. But for normal cases, the timeline is little lesser, which is 3 years from the date of filing of the annual return. So within that period, a tax officer is required to issue an order. And before that, before an order, there should be a notice. That notice timeline in case of 73 is 3 months from the date of issue of order. And in case of 74, it is 6 months. So we have understood there are two provisions, which is 73 and 74. The difference between two are allegation with respect to fraud, suppression, misstatement, and the timeline varies on the both. For 74, there is a 5-year timeline, and for 73, there is a 3-year timeline. And also notice also have a different timeline. For 73, there is 3 months timeline, and for 74, there is 6 months timeline. Now, why are we understanding these basic provisions? So this judgment of Madras High Court or Karnataka High Court are being dependent on these provisions. Let me just read 7310. The proper officer shall issue order under subsection 9 within 3 years from the date of furnishing of the annual return. So there is an order which an officer is mandated to issue within a period of 3 years, which is linked to annual return for the financial year. The words here are financial year, annual return, and order. So very clearly, these section 73 says for each financial year, there had to be an order which is dependent on annual return filing within 3 years. So law is very clear. Practically, it is very clear to say that for each financial year, there should be one order which is dependent upon annual return filing and within 3 years. Same provisions are akin in section 74. It says proper officer shall issue an order, which is one order within 5 years from the date of furnishing of annual return for the financial year. So, just to elaborate once again, the section 73 and 74 is dependent upon annual return filing for that financial year, and from that date, the due date to pass an order is linked. So for each financial year, there's a linkage with the annual return for that financial year, because the annual return is typically for one financial year. There is no annual return for multiple financial years. So for each financial year, there's a different due date. Now, why I'm stressing on this? Just to give you, as I told you, in the erstwhile law, which is service tax and excise, it's a very common phenomena under the indirect tax that every officer or any officer used to issue one order or one notice covering multiple years and multiple issues. And it's a very normal thing. During 7 years of our GST, this is the same practice which we have seen. All your bigger amounts, Infosys issue or bigger headlines which we have seen encompasses various periods. And just to compare with the income tax, in income tax, it's not the same. In income tax, there is a concept for one assessment year. For every assessment year, there had to be one order, there had to be a one show cause notice for the penalty. So how we are different in indirect tax, that indirect tax does not say you have to have one order for each year. But now reading section 73 and 74, it looks like under the GST law as well, now the officer is mandated to issue one order for one financial year, which we have read just now. It talks about order, which is a singular term, order within a period of 5 years from the due date of furnishing of annual return for the financial year. For one financial year, he has to issue an order. And show cause notice within 6 months if it's 74, and within 3 months if it's 73. So it's very clear now, reading of the law, it clearly says one order, one year, one order. Now, this slide, just to give you more insights, the government in 2023 has extended the timeline for passing an order under section 73 and 74. So they have extended 3 months additionally, they have given to the tax officers in 49th GST Council meeting to state that now additional 3 months have been given to them to pass an order under section 73 or 74. So this slide covers all my timelines for 17, 18, 18, 19, 19, 20, 20, 21, original timeline, then the extended timeline. So currently this is my extended timeline. Before this, an order is required to be passed by the tax officer. This is a HCN timeline extended, and this is a order. OIO is order timeline. So for 2021, the timeline for issuance under section 73 for an tax officer is 28th February 2025. So if you have any case which is pending before any tax officer for 2021, the due date for him to pass an order is 28th February 2025. Now, why I'm stressing on the timeline? So just to tell you, under the GST law, if an officer has not complied with the timeline, all the order which even correct or the tax demand is correct is still not allowed. It's not still valid. It is still invalid. So if the officer has not complied with the timeline, then order is incorrect. It's invalid. So this is important. And now, as I was telling you, for each year, there is a different timeline. For 17, 18, there's a different timeline. For 18, 19, there's a different timeline. 19, 20, also there is a different timeline. How officers are clubbing into one and issuing that? That is a question. before Madras High Court. I will dwell more into that. Till now, we have seen Section 73 and 74, which clearly says for each financial year, there should be one order or one show cause notice. Now, this slide talks about timelines for Section 74. For 17, 18, 18, 19, 19, 20, what is the timeline for issuance of the order and show cause notice, considering the extended timeline. So before that, he has to do that. Now, now we have understood the legal provisions. Now, what is the important points for as a taxpayer? If I have received an order or notice, what is the important point for me for this legal provisions? Or as a tax department, if I'm part of the GST department, what is the important point for me under this Section 73 or 74 in respect of passing of order or notice? And third, very important, what GST law says typically. So these are the important buckets which we have to understand. Whether you are a part of taxpayer, whether you are a part of GST department, or in terms of law, what law says, what are the important points. Now, as a taxpayer, as we have understood, the GST law says single SCN for multiple year is against the scheme. So we should have one financial year, we should have one SCN or one order. Now, it is important because it create, in case it, because there are different timelines, different tax positions, tax exemptions, statutory requirement for every financial year. There's a different timeline, as we have already seen. For 73, there is a different timeline. For 74, there is a different timeline. How can you club it and make it as a bunch and give me an SCN? There could be positions where for one financial year, the company has adopted a different position, and for other financial year, he has adopted a different position. Giving example, taking example for tax position, let's say for ISD, which is now mandated from April 2025, there could be corporates who were not earlier doing the ISD provision, who were not complying with ISD. But from April 2025, they are mandated to do that. So in such a scenario, for financial year 23-24, they are not required to do ISD because there is a circular, or they are not required to do cross charge. There's a circular for that. But from April 2025 onwards, they are being mandated to do that. So there could be different tax position being adopted by the companies itself for different financial years. Exemption. Assumingly, a company is eligible to claim exemption for one financial year, but later on, they are not eligible for doing that. But by way of a bunching of the notice, by way of bunching of the financial years, I will not be able to present my facts very clearly because he has just made one notice. And if I want to pay for one financial year and not want to pay for other financial year, I'll not be able to do that. So it creates a lot of difficulties for preparing responses. Also, it leads to higher legal expenses. Let's take an example. We have seen that in case of Infosys, there was a huge demand has been dropped on them, some 40,000 odd crore. Now, in the same HCN, the financial years are 17, 18, 18, 19, 19, 20, and 2021. So, for preparing the responses, we would be requiring the data for that, which could be very much time taking, which would require a lot of efforts. In case the GST department issues for each financial year, we would be less, at least we can answer for one financial year easily, wherein we have the data. And for second and third, we could have more time for that. Also, giving more example, assumingly a company has received a one order, which covers 4 financial years. Now, for pre-deposit, which is 10% for first appeal, it'll be a bigger amount. In case the officer has issued one show cause notice for one financial year, the pre-deposit amount comes down quite low. It also impacts the working capital. So that could also be a easiness for the taxpayer. Also, it leads to legal. In case it's a bigger notice, we would require more manpower, we would require more data for that matter, and more legal expenses. Because could be a reason a company has received a bigger demand and they would want to go to a commissioner appeal, but because of the 10%, they are not able to do, because it's a very important, very bigger amount as a pre-deposit. But in case they have a one each financial year, each order, they could do at least for one or two orders and they can easily file an appeal. So by doing this, it creates a lot of hassle for the taxpayer as well. However, it will always be easy for the department, because they will, it's easy for them. They have to prepare one document which covers 4 years, which has a huge demand. They have to do only one job, which is passing that order, adjudicate that only, and that's it. But under the legal framework, under the GST framework, it is not allowed. So that is the important points for taxpayer. As a taxpayer, we had to be very mindful that first, for multiple years, we should have multiple show-cause notice, as it create the ease. Now going to the GST department, what GST department is looking for doing this. Now we have understood how taxpayer is wanting. Now what is the context, or what is the rationale being given by the GST department by doing this all? So first, which I told you, they have already done that, and the service tax, excise, it's a very common practice across them. It's not a new practice under the indirect tax. It could be a new for the direct tax, but indirect tax, it's very clear they used to do that. And under the service tax or excise, there was no judgment, there was no high court judgment, there is no Supreme Court judgment on that. So it's a very norm to that. Also, by issuing a single SCN, it'll be easy for them. It's convenient rather than doing multiple documents. They have to upload on the portal, they have to adjudicate that. So it creates a hassle for them. Maintain the documents for that. So they will always wanting to do one HCN for multiple years. However, as a taxpayer, we should always tell them to issue multiple years. Here, I would love to take one example, which is a Madras High Court Una Minda judgment. Now, just giving a fact to that judgment. This judgment was issued prior to a circular being issued under the amnesty scheme. So this judgment is typically for the amnesty scheme, which the government has recently introduced under section 128A, which covers 3 financial years, 17-18, 18-19, 19-20. Now, the facts of this judgment is the taxpayer has received an order which covers 4 financial years, 17-18, 18-19, 19-20, 20-21. Now, this amnesty schemes only cover 3 years. And this judgment was issued prior to the circular, which the government has clarified that you can take the benefit. But considering the judgment frame time, the taxpayer wanting to claim the benefit of the amnesty scheme, but because the order was only one for all these years, he's ready to make the payment for 2021. He's not denying it. But because the order is only one, he was not able to do that. Now he has filed a writ petition before the High Court, and High Court in the Uno Minda judgment has categorically remanded back the order to the tax officer, stating that under the GST law, it is mandated to issue one single notice. Also, he is eligible to claim the benefit of amnesty scheme. However, because you have issued one order only, he is unable to do that. So for the ease for the taxpayer, kindly issue multiple orders for each financial year. For each financial year, please issue one order rather than bunching of them into one order, so that he can claim the benefit of amnesty scheme. And later on, the government has clarified same position under the circular, stating that if your period, if there is an extra period, you can claim the benefit. It's just that you have to pay a tax and interest and penalty along with that. But for 3 years, you can take the benefit of amnesty scheme, which is interest and penalty. So this is an important judgment which has same consequences under this topic. Now, in terms of GST law, the GST law is very clear. For each financial year, there had to be one order. Also, the phrase used under the law also says officer shall issue the order, one annual return, which is linked to the financial year to which tax has not been paid. So the GST law is very clear. It's very clear to say that for one financial year, there should be one order. Also, limitation, as we have already seen, limitation for every financial year is a different limitation period. So you cannot bunch it. Also, the annual return, which for every financial year, we are required to file an annual return before 31st December of the following year. Taking example for financial year 23-24, 31st December 2024 was a due date. We have filed a consolidated return for one financial year, which is a particular 23-24. In considering all these facts, we should have one single notice for one financial year only. That is as per law as well. Now, also, we have seen sometimes clubbing of financial year may not have any impact on the liabilities. That's true. Practically, there could be a situations wherein clubbing may not have any impact. Now, but there could be a mischief which being be done by the tax officer, considering that for one financial year, the due date has already lapsed. Now, by way of a bunching of the notice, he would try to issue an order just to overcome the limitation period. Now, here at this juncture, I would like to give you more insights towards the High Court judgment of the Titan company. Now, in case of a Titan company judgment, this issue have cropped up, wherein for 17-18, the timeline has already exhausted. And if the tax officer tries to do an order, it would be considered invalid. Now, by way of a bunching of the notice, he has issued an order. And this mischief has been caught by the High Court, wherein they have typically said which by crossing that limitation period, you are not allowed to pass an order. However, you have indirectly tried to do what you are not allowed to do. So this is incorrect. Please, I am remanding back the order or I am quashing the order. You are allowed to issue multiple orders considering the limitation period. So this is the important one. So that's the play being done by the tax officer, wherein by way of a bunching of financial years, they will always try to overcome the limitation period, which in case they would have done for each financial year, they would not be able to do that. That is the basic gist of these judgments. I will go into depth on the next slide as well. Now, this issue has been presented before the GST Council as well. In the 49th GST Council, wherein the government has extended 3 months for the issuance of order under section 73 and 74, they have also been said that it may be a situation wherein it may lead to bunching of the last date of issuance of show cause notice and order. So the GST Council is also aware that the tax officers may try to circumvent and would bunch financial years, wherein in case any financial year, the limitation period is already over. So they will try to bunch it and just make one notice so that anybody cannot challenge it. And the tax or litigation would start with that. So the GST Council has also been cognizant of this part, that by way of extending of timeline, it should not happen that there is a bunching being done by the officers due to last date of issuance of order. So they are also cognizant of this part. And this has been typically being recorded under the minutes of the GST Council, which is available in the public domain. We all have the access of this. Now, some of the tax officers have very categorically said the law does not explicitly prohibit a consolidated SCN. Now, during all these judgments which we are referring to, there is a rationale being provided by the GST department to say that even if you are reading section 73 or 74, there is no explicit. There is an interpretation by the taxpayer, wherein on the basis of that interpretation, we have been called that for one financial year, one order should be there. However, they have very categorically said there is no explicit provisions. Maybe if we have more judgments or till it reach the apex code, we would have more clarity in this context. So high courts, which is Madras High Court and Karnataka High Courts, have set aside all such SCN despite the prevailing practice. So I have very categorically told there's a prevailing practice from the earlier regimes which says that, okay, you can do that. You can have one order or one SCN for multiple tax period, as it is easy for the tax department to do that. However, tax department still have a point to say that there is no explicit provisions. It's just an interpretation by various high courts. And as we have more high court judgment or Supreme Court judgment, we will have more clarity on this aspect. Now, this is the most important point. What are the rationale being taken by the high court? So just to tell you, there are couple of judgments by Karnataka High Court and Madras High Court. Madras High Court has rendered Titan, Uno Minda, and Karnataka High Court has rendered Bangalore Club, Veramax, and there are a couple of other judgments which follows the same rationale being taken by the Madras High Court. Now, Madras High Court takes into consideration all these pointers. There is no express provisions to allow issuance of single notice for multiple years. So, as the department says, there is no express provision to do one notice for multiple years. They have taken on the basis of section 73 and 74 to state that the law is very clear. You should have one single notice for 1 year. And in the law, there is no allowed to have single notice for multiple years. Issuance of demand. Any demand under section 73 and 74 is a substantive action. And it had to be read strictly and express provisions. So as we have already seen, the law is very clear. 73, 74 says you cannot do that. So it is a very substantive action. Express provisions are there. And as a tax officer, you had to comply with that. And this has been done on the reading of section 73 and 74, which indicates a strong ground for separate SCN. The important point which the High Court have said, tax laws must be interpreted strictly on what is expressly stated, no implied meaning. When there is a clear provision under 73 and 74, no officer is allowed to overcome that or try to do anything which is beyond under the law. You have to comply with the provisions which clearly says for each financial year, the due date is linked to the annual term and the order has to be passed within that period itself. Implied meaning, in case there is no express provision, implied meaning can taken only when express provisions are absent. In the instead case, there is a clear provisions. Now, all these judgment, just to tell you, all these judgments are based on Supreme Court judgment of J&K versus Caltech India Limited. This is an important judgment by Supreme Court. It's a very old judgment under the petrol and allied products. It's on the sales tax on the petrol and allied product, I would say. Now, in this judgment, the mischief has been done by the tax officer, wherein he has tried to bunch two tax periods on which one tax period was not allowed or the limitation period has already lapsed, and he has bunched that into one and issued a order. Now, Supreme Court, considering the mischief being done by the tax officer, has very categorically said, in case there is a part period on which tax was leviable, but there is a period on which tax demand is invalid because of the limitation period. In such a case, bunching of the financial was held impermissible. All the High Court judgment has relied on this judgment itself, which is the Supreme Court judgment, State of J&K versus Caltech India Limited. All the judgments which we are talking about, whether it's Uno Minda, whether it's Bangalore Club or Veramax or Titan Company, have relied on these judgment to state that in case the tax period, GST department has or tax department has clubbed two periods on which one period is something which is not allowed and one period is allowed, then only you are not allowed to issue an order. So this is a very important judgment to state that. So there is no, as of now, there is no judgment. As of now, there is no judgment on this issue currently. High Court, even though we have only two High Courts which have rendered the favorable judgments in this context, which is Tamil Nadu and Karnataka, these judgment gives a persuasive value to other High Court as well. So even though we don't have a Supreme Court judgment or we don't have a other High Court judgment, these two High Court judgment give a persuasive value to other High Courts. Now, this is the last one, I would say. The important judgment, as I've referred, is the Supreme Court judgment in the case of J&K versus Caltech India. High Court judgment, which are the most important, Bangalore Club, which is a Karnataka High Court judgment, then Veramax, which is a Karnataka High Court judgment. The last one is Titan, which is the main judgment rendered by Madras High Court. That is the end of my presentation. Thank you. I can take the question which would be available. So there are a couple of questions being under this. Can there be a single HCN for 3 years and DR3 Form DRC-03 for single or explaining for all three orders? So the question here is, I have one single HCN. However, there are three different DRC-07 for that typical years. So I think the officer is very mindful. He has issued only one HCN, and later on he has realized that he should issue single order for each financial year. To overcome that, he has issued DRC-07, which is the final order for all different each year. So it can be currently, yes, it is there. It is a practice under the GST department. They are doing this. To overcome that judgment or overcome that provisions, they have realized their mistake and they are issuing different orders for different years. Rather, even though they have only one single HCN, yes, it is possible, but we can always take a stance. Just to tell you, this judgment is important when your limitation period for one financial year is already exhausted. In such a scenario, you can do that. In case there is no benefit, I don't think so you will have much benefit to that extent. Even if you take even if you try to take any benefit on these judgment. Now I will shift to next question: whether Titan judgment rejects, quashes, set aside the entire HCN and demand, or only to the extent the same was time barred by the law. So in case of a Titan judgment, they have quashed the HCN, entire HCN, and they have sent back, they have given an option to the tax department to state that kindly issue one HCN for one financial year, considering the limitation fear. So in case of a Titan judgment, the tax officer has played a mischief. He has tried to overcome the limitation period. So the High Court has quashed it. Now they have sent back the time. They have given a liberty to the GST department to state that consider the time limitation period and then you issue a show cause. So indirectly they have quashed that period which is beyond the timeline. So can the interest be demanded beyond 3 years? I think interest can always be demanded beyond 3 years. The question is not about interest. Whether the demand, in case of your demand, order or HCN has to be issued within the period. Interest, if you check whether this period, whether the demand is valid or not. In case the demand is valid, interest can always be asked. The question here is demand, whether the period of issuance of the order or HCN is within the timeline or not. If the order of interest is not within the timeline, that is also incorrect. So that period you have to check. Period of issuance of order or HCN. That is the most important. So a person got a combined HCN for 3 years of 2.2 crore, out of which one first year has 20 lakhs, other have 1 crore each. The HCN was issued by additional commissioner. If HCN are to be issued separately, whether I can argue that the issuing made is not a proper officer, hence the demand cannot be made by now. So I think here the argument is different. My webinar or my topic here is within the time frame, whether he had to issue one order or one HCN or multiple. If you are taking whether he's a proper officer, I'm not sure whether additional commissioner or timeline you're requiring. My topic here is, or my contention here basis the judgments are that you can take the contention when there are multiple orders, and you can always say you have to issue one order for one financial year, considering the limitation period. The argument is not about whether he's a proper officer or not. That you have to separately check within the threshold of under the GST law, whether he's allowed to issue a notice or not. That is a separate contention, and that is basis the different amount. I may not be able to tell you. If so, under which section? I told you the intention of the webinar is not on the proper officer. Here the intention was of the whether he can do a combined HCN or not. I think I have the next question is, can the interest be demanded under section 73? So whether interest is payable or not, the question here is whether he can pass an order within the 3-year timeline or not, whether he has passed an order or HCN. The demand is valid only when he has issued an order or HCN within the timeline. Can Supreme Court order help in HCN for multiple years? So as of now, we don't have any Supreme Court judgment in the context of GST law. There's a judgment which is based on erstwhile law, which is the Petrol Act, sales tax on the petrol. The High Court judgment has relied on that. So we may have to wait. Currently, department has also not got into the SLP before Supreme Court as of now. So we may have to wait and see how it turns around in the apex court, or whether other high court issues something new, or whether they are favorable to the SSE or not. We may have to wait. But currently, we have favorable judgments, which will have a persuasive value to other high courts as well. So we can always use that judgment in our favor to state that, okay, there are favorable judgments and kindly give me the benefit. We can always take a persuasive uh, argument before any other high court or tax officer, before the tax officer also. In my practical example, I have currently seen in Karnataka and Madras, the tax officer have started complying with these judgments. So if you are part of these two states, you would on ground, you will see that. In case you are not part of these two states, you can refer to that these judgments before any tax authority or before any high court as well. And as a matter of persuasive, they will consider that. So they cannot deny the part that there are judgment in these contexts. They were always open to do their rational. They can take or not, that's a their call. But as a corporate or as a SSE, we should provide them that these are the facts or these are the judgment which is available. And in terms of GST law, they are mandated. So in that sense, we can take the benefit of these judgments. Uh, I think my deliberation is completed. I have taken all the questions. Any other, you can let me know. I think I've taken all the questions.